Hello, everyone. Welcome to Carolyn's Corner. We are so excited. Bree and I have a special guest today. We have Laura Crawford, attorney at law. And could you maybe tell us a little bit about your practice and what you do?
Yes, I have a estate planning practice in Orange. I started it in 2016. I handle putting together wills and trusts, a whole full comprehensive estate plan that also does include guardianship paperwork as well. I do represent families in probate, and I can also do conservatorship.
Okay, great. Thank you. And that is Orange, California.
Yes.
Too. Okay, so let's just dive right in. I know people get a little scared when you start talking about trusts and probate, because obviously then you start thinking about, our life.
Yes.
Right? So
Yes.
that is a challenge probably for you in your practice.
Yes,
but,
it is.
I just thought we could kind of start in with what happens if you don't have a trust.
So if you do not have a trust and you have no other means set up to avoid probate, which I'll kind of touch on in a little bit, then you will have to go through probate. Probate is a legal proceeding that's used to wrap up and distribute a person's estate. So paying creditors, paying out to beneficiaries. So it's a court process. It's very long. Typically takes about 1 year. Post-COVID, it's even more delayed. So I had a probate recently that we filed prior to COVID, but post-COVID, it took almost 2 years.
Wow,
to actually pay out.
Yeah.
And that was a very simple estate, no creditors, no one fighting over things, it just as simple as a probate could be, and still took that long. And so with that comes, your accounts are frozen for a while, family doesn't have access to money. So avoiding probate is a really, really important thing to do for your loved ones. It's already so stressful when you're dealing with a loved one's death to then have to add on the stress of a court procedure. Mm-hmm. Probate is also very expensive. Not only filing fees and other fees along the way, but the attorney actually gets paid a percentage of the estate. And that would be the gross estate, not just what your if you have a mortgage for $800,000 and your property is worth $1 million, most people would think, oh, I'm a $200,000 estate. Nope, that's not how the court sees it. You have an estate of $1 million and would have to pay probate fees in accordance with that.
Right.
So just to give you guys some numbers, it's 4% of the first $100,000, 2% of the next $800,000, 1% of the next $9 million, and then 0.5 of the next $15 million. So as you can see, that adds up pretty quickly. Yes. I think, if a estate is worth like $700,000, the fees are going to be about like $17,000.
Right. Yeah, I had my first dealing with a probate was I got a lead from somebody online, and they were shocked to find out that they did not have, their parents did not have their home in a trust or their entire estate in a trust, and they were all out of area. So they called me, didn't even know who to call. So I found them an attorney, but they were really shocked that it was gross because their parents had a mortgage of about $500,000. We ended up selling pretty much the same numbers you were just talking. We sold for about $705, and it was treated as if it was all, gross, like as if they were actually making money off of it, and they weren't.
Yes.
So they were very shocked.
Yeah, so you could even get in the situation where after the mortgage is paid off, you're like having to come up with the funds on your own to pay the attorney fees. And then the executor is the person who would represent your estate. So in addition to the attorney, you have an executor. They actually are entitled to that full amount as well.
Just seems stressful.
Yes.
A lot of work.
It is stressful. It's a long process, and it's just, families are already at their worst, grieving through a loss, and this just adds a whole other layer.
Well, I kind of saw, because I have been so involved with short sales and bank-owned properties when I started in my career, and it felt like going through a short sale even though it wasn't short, because they had to supply, the family had to supply all this documentation of everything, all of their entire assets, and it was just like when you have a short sale. So it's just a lot of work.
Yes. And then something other people don't necessarily think about is when something goes through probate, the the accounts are all frozen because no one else is able to have access without that court paperwork. And that court paperwork, you do get it at some point during the beginning of the process, but it can take months to actually have access to bank accounts. And meanwhile, there's a mortgage that needs to be paid. And so if you're, not fabulously wealthy, which I don't think most of us have the money to pay for our own mortgage and pay our parents' mortgage, then the property could have the risk of going through foreclosure.
Right. Which I've had that experience as well. And my advice to my client at that time, because it wasn't much, the mortgage was quite high, is, well, you could just let it go to the bank because if you don't want to do the work.
Yeah, that is tough.
Yeah, it is hard. Okay, great. Well, thank you for describing how probate works. Have you ever had any experience with probate, Bree?
No,
Not
I
yet?
haven't. Nope.
Okay, well, I'm sure you will at some point.
Yes.
Fun stuff.
Well, now we can go into, what if you have a will? And what happens if you have a will? Like, could you describe the different scenarios with the will?
Okay, so this is a really big misconception that I come across with my clients is, oh, I have a will, so I'm good to go. I won't have to go through probate. And the will is actually the written instructions for the court. So the will does not avoid probate whatsoever. It just, instead of, if you don't have a will, you're considered to have died intestate, and your estate will be paid out to your closest living relatives, whatever level that may be. With a will, you can actually state who should receive what and what amount. So if things happen, if you're disinheriting someone, that would be written in the will. Where if you died without the will, a person you might not want inheriting something might be the person who's going to get it. So with the will, you have a little bit more control. You name who the executor is going to be. You name who your beneficiaries are, how much they're getting, what specific items they're getting, but that still all has to go through the court. And it's really the same exact process, will or no will, time-wise and expense-wise.
Okay, great. Thank you for explaining that. How do we avoid probate?
Okay, that's a big question.
We don't want probate.
There's
I wanna do
a few ways to avoid probate. The first would be holding your property in joint tenancy. So I think you probably see when a married couple, or could be siblings, partners, whoever, buy a property, they hold it in joint tenancy. And what that means is when the first person passes away, the joint tenant just automatically becomes the sole owner of the property. So you avoid probate on the first death of the first joint tenant, no matter how many joint tenants there are. But once you get to that last joint tenant, if the property is not held in a living trust, that person is still going to be, their estate's going to be subject to probate, and that would include that
Right.
property.
So if you have a married couple, if we take that in, for heaven forbid, plane crash and both are gone, then yeah.
Correct, yeah. So, usually with spouses, I would say you have a little bit of, you're rolling the dice that you're not going to simultaneously die, but as we know, that does happen. So if, you were just counting on that the last person would then get their affairs in order, we never know when death is going to happen, unfortunately. And then another thing about joint tenancy, some people have thought like, oh, okay, well, I'm going to add my child as joint tenant. That way I don't have to pay to put a trust together, and I avoid probate for myself. Yes, that's something you can do, but I highly, highly do not recommend it. One, I don't want to get into too much tax stuff, but when you sell a property, you have capital gains based on what you bought it for and then to what you sold it for. Well, if your child is put on the deed, let's say you bought the property for $200,000 and it's now worth $1 million, which is really, really
Common. That's common.
Yeah, with property values now, like that's a really realistic scenario.
Yes.
Instead of your child getting the value of the date of your death at $1 million, selling the property at $1 million and having zero capital gains, they would then their basis would be the $200,000. So then they're paying taxes on that $800,000.
Right.
So it's not advisable.
Right, which their deduction as a single person would only be $250,000.
Correct.
So they would have to pay capital gains on the remainder,
Yes.
which would be a lot.
Yes, and then creditors can also take your jointly held property. So if your child got in some trouble, got in a car accident, has a judgment, the creditor can actually attach that judgment to your property. So multiple reasons why that's not the best idea, even though between spouses it's a great way to avoid probate. There is also something called a pay on death arrangement. You list, on your bank account, when I die, this account goes to whoever
Right,
you
I've heard of people
whoever
doing that.
you
Yeah.
list. You can do that with a deed as well. You can record a deed saying when this person dies, when I die, this person gets the property.
Yes.
However, in that case, it really doesn't provide for any contingencies. So if that person predeceases you and you never change it, or you die simultaneously, that property is still going to have to go through probate.
Okay.
So then the best way really is to have a trust.
Yes.
Yes.
Which is
We're
right
right
here.
here.
That's what this is all about, kids.
Yes.
Yes. So with a trust, you are creating this separate entity called a living trust, and you are actually placing all your assets in the name of the trust. So at the beginning, you are the trustor, the creator. You are the trustee, the person who oversees and manages the trust, and you are the beneficiary because you're holding it for your own benefit. So then you would I would prepare a new deed, or someone would prepare a new deed granting the property from yourselves as individuals to yourselves as trustees of your trust. You get that recorded, and your trust is funded, and the property is then held in the name of the trust. So when you pass away, the next person that you list as your successor trustee would just automatically come in and be able to oversee and manage. And so obviously properties are the big assets that we're talking about, but the same goes with bank accounts. Any estate that's over $250,000 has to go through probate. So basically, if you own property, as we're talking gross value,
Right.
you're going through probate.
Right, and even mobile homes, like Bree and I were
Correct.
talking earlier, I mean, our mobile home values in California are equal to that too.
Yes.
Can I cut in really quick?
Yes.
I do have a question for why people might opt out of going to a trust. Is it a big fee?
Not when you look at the numbers.
Okay.
But yes, it's nothing compared to that. It depends on the attorney. My basic package is about $2,500, which can be a big amount for people. And so, that's something that, it's easy to put off. We're not all expecting to die tomorrow. But the reality is, tomorrow's not promised for us. We
Right.
never know what's going to happen.
That's a great question. Thank you for asking.
And yeah.
Well,
And
that's what I-
when you look at the numbers, I don't think people realize how much money is going to come out of their estate through probate. And if you're looking
Totally.
at it like you're putting out this small amount when you're still living versus you're depriving your beneficiaries of such a huge amount.
Well, not even just depriving, you're also giving them all this work and,
Yes.
and potentially trauma, because it's traumatizing for people. They're dealing with someone passing, and then they're having to deal with all this financial information
Yes.
too. So
Yeah.
it can be very overwhelming.
I would say just court in general is a stressful
traumatizing.
situation no matter what you're there for, and we want to avoid it at all costs.
Okay.
Um,
Great. Okay, so let's talk a little bit about how trusts then could be the different ways you could set it up. You talked about just like the basic, who when you're setting it up for yourself, but how you could set it up, as far as having a successor trustee rather than having just, multiple trustees. You could explain a little bit
Okay,
about that?
yes. So yeah, when you first create your trust, you are encompassing all three roles: trustor, trustee, beneficiary. No one else can ever be the trustor because you are the creator of the trust.
Yes.
But you do want to name a successor trustee, and that would be the person who would come in and oversee and manage on behalf of the beneficiary. And just because someone's named as the successor trustee does not automatically mean that they are a beneficiary or that they are able to spend these assets for their own personal use. A lot of times, I work with a lot of families that have young children, and so you're not naming a child as a successor trustee, but you're naming your children as your beneficiaries.
Right.
And so I always recommend to list a few people. Just you don't want to constantly run to the attorney to get amendments if something happens to someone listed. So you want to, really prepare for as many potential contingencies as possible. So I do recommend, if you have a couple names, to put a couple names. So you can have just an individual trustee, or you can have co-trustees. So when you and your spouse create the trust, you're initially your co-trustees. It can get kind of difficult making multiple people agree on things, like, are we selling the property? Are we renting out the property? I really just advise whatever is best for your family and your needs.
Yeah.
You know, if you have a blended family, you might want one child of one spouse, one child of the other spouse, to make sure
Right.
that they have to agree and are all on
Right.
the same page.
That's a good idea.
But, you know, like, if there's multiple kids all from the same parents, I recommend just choosing one.
So then what happens if they do put all the children? Because I am in that situation.
Okay.
Yeah, she can speak to this.
What happened? And you can also list, like, you can say multiple trustees, but we only require one signature, which, if the people get along, is good, but if they're not on the same page, you're giving someone the authority just to go do it on their own.
Yeah.
But it can create some drama because they have to agree with what's best. And unfortunately, if they can't agree, you might have to get some court involvement to petition for the property to be sold.
Yeah. Okay. Well.
Right. Yes. So and the interesting thing is oftentimes the family members don't know that there is a successor trustee or there isn't, and they don't really understand, right? Like in your case, you want to speak to what just happened?
I mean, I am dealing with a close family friend whose mother just passed away, and he's the executor of the will, so he thought he was the executor of the trust when it clearly states on the trust, but he's not very familiar with them.
Okay.
That he thought he was going to be it, but all siblings are successor trustees. So he was like, oh, they don't have to sign. I was like, yes, they all actually do. And he was like, that is going to be difficult.
Yes.
And
Yeah.
so
And so normally the trust should state the signature authority, but
I
you
don't
know,
think this
it
one
doesn't
did.
necessarily always happen.
Right.
Should, and then, yeah, just to, you know, people get executor and trustee confused.
Yes.
The executor is the person who would represent the estate if it had to go through probate or the court process. Successor trustee is the person who oversees and manages the trust.
Exactly.
And
yeah.
ideally, like, I usually state that the then acting successor trustee would be the executor if that was necessary. But sometimes they list different people for, you know, who knows why, but then that does add a lot of confusion.
So can you speak to, because we had talked about this a little bit before, if you have an executor, because I don't think we had mentioned this, and you do have to go through probate, that the executor actually can retain the same amount as...
Yes. Yeah, I think I did mention that. But yeah,
okay.
so that's, you know, those numbers that I read off earlier, double that. I mean, the executor doesn't have to take the fees, but it is a lot of work. So
But what about in the case of a trust?
So with
Is
a
that the same?
trust, you can actually limit that. You can state that the trustee asks for no compensation, or you could state that they would receive reasonable compensation that, you know, a professional fiduciary would receive. So that's based on the size of the estate and what the going rate at the time in your county is. So generally I see, like, when it's an adult child being named as the successor trustee for them and their siblings, they usually don't get any compensation. And it's kind of like, you're the responsible child, or you're the
Right,
oldest
right.
child, so this is just your
It's
duty.
an honor, people.
Yes. But, you know, my parents named my older sister, and I'm not mad about it. So,
Even though you're the attorney, that's pretty funny.
so then, yeah, you can list, like, the flip scenario. If you're, you know, for me, whoever is my successor trustee would be holding the assets and managing for the benefit of my girls. When it's a family member, you might say, no, like, my mom, my sister would never take money away from my kids. But if you're having to ask a family friend or someone, it is a lot of work. And so
Right.
you can list that they should be
Certain
paid for their services. But it's really just dependent on the situation and what the trustor decides.
Gotcha. So question, if the other siblings were not listed as successor trustees, would they get compensation?
No.
That is why then.
Yes.
Okay.
Yes.
Okay. Good to know.
Yes. So yeah, there's situations where they they might all, but if they're the only beneficiaries and you're getting compensation, all of you, there's no point really. But if it's one person doing all the work for the benefit of multiple people, you know, it just depends on how the trustors want to set it up and what's
Right.
best for that scenario.
Right.
Gotcha.
And we hope that we all get along. And that's
Yes.
a big part of it too. Because
Yes,
if
for
you
sure.
if you're working on behalf of multiple trustees and there's a lot of dissension and issues going on, that's hard.
Yes.
But of course, the parents never think that their kids are going to be in that situation probably, so they're not really necessarily accommodating.
Yeah. It's just amazing, like saying going through probate as well, but just, you're already dealing with so much grief, and money and assets bring out the worst in people.
Yes.
And fighting, and people get greedy. So, if the situation is right, it is preferable to just have one person, and that person makes the decisions, and the other people have to go along with what that person said, because we're following the trustor's wishes.
So do you have any interesting stories you want to share with us about a trust situation? Anything? I know we talked a little bit about some probate stories, but anything around trust?
For trust, nothing too exciting quite yet. I think I haven't been practicing long enough to have some really horror story.
Yeah.
So far everyone has got along. Most of my trusts are not being administered yet because
okay.
my client, I've only had one client die.
Okay.
And that was, I did the grandparents, I did the parents, I did the kids. The kids were friends from high school. So that all went very smoothly. So nothing too exciting yet, but yeah, I have seen, I've had to review some trusts from people where, dad's getting older and we're afraid that someone's going to come in and take advantage of him.
Right, caregivers.
Because that's the scary thing. Yeah. So, and there's only so much you can do to protect yourself, unless you're going to go to court and state that your parent is incompetent and that they can't make any more changes to their trust. Thankfully, no super close stories on that, but that's something that can happen is people come in and, try and get extra money for themselves or try and get someone pushed out. But unfortunately,
said, money brings out the worst in people.
The basic trust is revocable, meaning you can change and amend it throughout your lifetime, which is a really big benefit because you can make changes and adapt as you grow
quick
and
question
adapt.
Around that then. If you do have significant changes, every single time there is a change, then you would go back to your attorney who crafted the trust in the beginning?
Yeah. You can ideally go back to that same attorney. I've done a lot of restatements, which is actually restating the entire trust. We recommend every 10 to 20 years that you review your trust, maybe want to restate the terms, make it, updated with the current law. It retains the same trust name and signing date. So you don't have to go retitle assets.
Gotcha.
But you're essentially writing a brand new trust.
Okay.
Or if you just decide, I don't want this person to be my successor trustee anymore, or this person passed away, so I need to rearrange some things. That would require going to an attorney.
Your kids are adults now.
Correct.
And you can have multiple trusts.
You can. I'm not sure what the benefit would be. Depends on the situation. But ideally, if you're, married couple, you're having one trust, unless you have separate property you want to keep, but there's no limit.
I've seen separate property.
My family does. Yeah. We have these groups of properties in this one and these in this one because they're just for different family members later.
Okay. Yeah, you can set that up. Yeah, my grandpa was very generous and set up trusts to pay for college. So
that's nice.
He had, a trust for each grandchild to pay for college. So yeah, the
and
trust
property.
Yeah, trust can be there's no magic formula in that they don't all look the same, and so you can set them up for so many different reasons and purposes, and really tailor it to meet your needs. And yeah, I said, I like to work in as many contingencies as possible to avoid having my client have to make amendments constantly. But sometimes it's unavoidable. If you have a falling out with a person or someone died and you're to the end of your list of beneficiaries, you might need to go in and make a change.
So I have one last question. I don't know if Rhea has another question, but what about purchasing property in a trust for investment purposes? No, you can also do it as an LLC, but under what circumstances would that be beneficial?
Just to avoid probate. There's no real tax benefits to having it in the trust. When it's in the trust, it's treated as your property.
Personal property.
Protection.
So until it's until it's irrevocable, it's, nothing really changes with the way you treat your assets. So you still have it's your Social Security for tax purposes. So if you want an investment property in an LLC for tax purposes, that would be a better choice. But you can put investment properties if it's just, not with other partners. It's just, a separate family home that we
Right,
have
kinda
for
like what you were
investment
talking
purposes.
about.
You can
Yeah.
put it in your revocable trust. And then once the trustor or trustors pass away, then the trust becomes irrevocable. And at that point, there is some benefit for the beneficiaries. Once it's irrevocable, creditors cannot come in and take those funds. So long as things are held in that irrevocable trust, if you had, high credit card debt, or you get in a car accident and have a judgment against you, the money that's held in that irrevocable trust cannot be used to satisfy those debts.
Okay, so irrevocable means can't be changed.
Correct.
And revocable can be changed.
Correct.
Okay.
And so generally people set up a revocable trust at the beginning. You're going to make changes. Irrevocable trusts can be set up initially that way if it's for the benefit of someone else. If you need to then, you need to qualify for veterans benefits, it's Medicare, that kind of stuff. You basically, in an irrevocable trust, you're kind of locking up all your assets and you actually no longer have access to them. So then you can qualify for those benefits and preserve this money for your family.
Okay.
Gotcha.
Okay. I was just talking to someone about that actually.
Yeah.
Just last night. So
Yeah, so the attorney that I first started working for did a lot of trusts like that. I in my own practice, I feel like I have a little bit of a younger clientele, so we're not quite
Not
to
there.
that point yet. So primarily revocable. But yeah, once you pass away, the trustor passes away, no one else can make changes to the trust, so it becomes irrevocable.
Gotcha.
Great.
Set in stone. Yep.
Very cool.
Well, I think this has been really informative, and hopefully all of you have gotten a lot out of this, and you now know if you don't have a trust, please go get yourself a trust, because none of us want to be handling your probate.
oh, gosh.
Yes.
No.
We'll do it, of course, if we love you, but we
We'll
prefer
just have a
not to.
headache. I do have one thing. Can you shout yourself out, like where you can find you, like
Yes.
Instagram, like everything?
I don't have business. This is something that I need to get on, and maybe you're
Yes.
going to be the push. But at this point, my email, lauracrawfordlaw@gmail.com. You can always contact me on my cell phone. Let's stick with email maybe on the
Alright.
podcast.
Okay.
You email me, and then I'll give you my cell phone number.
Okay.
But yeah, that's next on my to-do list, is to expand my social media presence.
Yes.
All right,
agree.
great. Well, thank you so much for
Thank
being
you.
our guest.
Thank
We
you.
really appreciate it.
Thank you for having
And
me.
we'll see you next time on Carolyn's Corner. Thank you.